So it's delightful to start off your series, and congratulations. I think it's a very good idea, and if this videocon works and you can see my face and interact, it would be a very good way to have a lot of people who would be happy to join these sessions to have a discussion. So let's start with arbitration and India becoming a global arbitration center. Now all of you know, or all of you must have read, that the real problem with India in terms of being an attractive destination is that we are something like 182 out of 184 on the index of ease of doing business. We just tend to, unfortunately, make life more difficult and complicated than it needs to be. And one of the areas where we have really overcomplicated our world is in arbitration. Now, why is arbitration important? Why is it just important as an institution? And the reason it's important, especially in India, is because it is really supposed to be a very effective alternate means of dispute resolution. We all struggle today with the fact that we have millions of cases which are in the backlog at all levels of our courts, district court, high court, Supreme Court. And the fact remains that if a litigant does not see the end of his trial in 15 years, then really that is not an effective means of the delivery of justice. And arbitration is supposed to be a parallel, quicker course of getting your final decision. So let's say, so as AZB we do arbitrations in India, and we do arbitrations in Singapore, and we do arbitrations in London, etc., etc., etc. So typically, if you had an arbitration in London or Singapore, we would be able to get a result within 12 to 18 months. If you have a domestic arbitration in India, we normally tell our clients that you should be looking to get an award in 3 points. So 300 to 400% longer. And that obviously is a disincentive for anyone who's coming from abroad as a foreigner to actually want to choose India as the seat or the venue of arbitration. If you have a domestic to domestic award, you are simply stuck with a 3 to 4 year arbitration process. And don't forget, that is just the award. After that comes the appeal, the further appeal, and the further appeal. So why is this the case? Now, under our Arbitration Act, we have Part 1 and we have Part 2. Part 1 applies to domestic arbitrations, very simply put. Part 2 applies to foreign arbitrations. And there was, as you know, a huge confusion which started with the Bhatia case. Are people alive to the Bhatia case at all, or shall I give a summary?
No, ma'am, I think all of our students have a fair idea of the Bhatia judgment.
Alright. So, as you know, as I always laugh, Bhatia was really an attempt by Justice Varyava to help the litigant. And why? Because Part 1 and Part 2, as drafted, were such that the two did not converge. You were Part 1 or you were Part 2. And as you know, Part 1 had Section 9 and Part 2 had no equivalent. And therefore, in order not to deny the ability of a party pursuing a foreign arbitration from getting the interim reliefs of a court, Bhatia read in Part 1 into Part 2 unless excluded. And of course that resulted in everything becoming a Part 1 arbitration, everything becoming subject to Section 34, and therefore really the foreign arbitration process got derailed completely. Having said that, we now have Balco. Balco itself, I remember my father telling me, because he argued and lost in Balco. And when I was teasing him and I said, well, I'm very happy that you have lost Balco because really Bhatia needed to be fixed. He laughed and told me, operation successful but patient dead. And that is simply because if you look at Balco being prospective, you are now looking at Balco being applied for arbitration agreements which were entered into after September 12, 2012, I think. Bhatia was a 12 judgment, or was it a 13 judgment? So all the old arbitration clauses, which are the legacy clauses that we are all litigating as lawyers and counsel, are pre-Balco. Now, what does Balco say? Balco doesn't help the cause at all, if you ask me. Because what Balco is saying is, by the way, I think Bhatia was overstepping when he allowed Part 1 and Part 2 to converge. Part 2 is separate, Part 1 is separate. So, by the way, if you are picking a foreign seat and a foreign venue, guess what? With eyes open, you are going into a situation where you cannot approach the Indian courts for Section 9 reliefs. Finished. Now, look at where that leaves someone like AZB. What do you advise a foreign client? Is it better to have a foreign arbitration and have no access to Indian courts, when really the first thing you would want to do is actually rush to an Indian court for protection? There's a shareholders agreement. There's a right of refusal given to a foreigner. The Indian shareholder says, I'm going to breach that. I'm going to sell it to Zia. The foreign guy says, you can't do that. I have an agreement and you have to give it to me. He says, no problem, I'm still going to sell it to Zia. Where do you go? Do you rush and try and form an arbitration panel overnight in Singapore or London? Do you get them to hear the matter overnight? And after you got them to hear the matter overnight, are you in a position, assuming you can do that, to come to India and get reliefs as an enforcement of an interim award, assuming it's an award, all within the time that this guy says, I actually sold the shares to Zia Mody, right? So, really, post-Balco, we have debated in every situation. Depending on the facts of the case, we try and project a bit as to where the disputes are likely to arise, what hat are we going to wear, and in some cases, even if it is a foreign party, we have actually chosen India because the right to approach the courts for relief is more important in terms of protecting us as a party. Now what has happened, and this is an interesting phenomenon that you should know about, is that the Singapore International Council of Arbitration and the London Council of International Arbitration in London and others around the world now have a clause called an emergency arbitrator clause. And an emergency arbitrator clause is one where you can actually ask Singapore to appoint an emergency arbitrator overnight who will actually hear parties on the phone, basically, with very little pleading, on a Saturday, on a Sunday, and within 24 to 48 hours, issue an emergency order. We had a case like that, which had an emergency order in Singapore, which basically awarded protection to our foreign party. So the foreign lawyers came to us and says, now, can you enforce this? And when we did some research, we found that this was not really, under Indian law, probably going to be considered an award. it was probably going to be considered an order. And an order is not enforceable as an interim award. So we rushed to court, and before that, from a practical perspective, we served this very solemn looking emergency order on the banks where the Indian party had his bank account, and very firmly told the bank, you cannot allow this guy to withdraw any money. The bank, not knowing the difference from an award and an order, didn't allow him to withdraw money. And within those 4 or 5 days where we got a window, we rushed to the Bombay High Court and we filed and we said, we need protection. The issue whether this is an award or an order is still basically outstanding. We think we might get a leg in, but at least we got protection. Now, in the Balco case, post-Balco, frankly, this may become even more difficult because the two parts have to completely be separate. So in this environment, when you have only an either-or situation, India becoming a global arbitration center at this stage is a long while away. So what has been happening? Have any of you read the Law Commission report on changes to the Arbitration Act 1996, which came out a couple of months ago? Okay. So what the Law Commission decided to do, and I was one of the members who was assisting in that particular report, just as an outside external help, is we decided to actually put a set of serious amendments to the Arbitration Act to basically make it much more user-friendly and to basically make sure that India could become a significant region for good arbitration. We made Balco retrospective. We tweaked around with the public policy exceptions, which saw pipes and the others had really broadened far too much. And we put in a part A and a part B in the domestic award challenge. It was very interesting because there were a few outside practitioners like myself, Darius Khattala, Dushyant Dave, and all of us were saying, no, you really need the Renu Sagar test. You should not have a saw pipes test. And there were a lot of people there from the government and from the ministries who said, we worry that when you have a domestic arbitration, all of you are only thinking of the billion-dollar, multi-million-dollar arbitrations. There are a lot of smaller arbitrations, and guess what? Government is one of the biggest litigants in arbitration because all these government contracts have an arbitration clause, a lot of them. And they said it is not unheard of that there could be collusion, there could be corruption, and if we have no ability to challenge these awards, then the government will not approve this sort of amendment. And so we had a part A and a part B, where we had in a part A one domestic party and another foreign party. Then we applied the Renu Sagar test, or we recommended. And part B, where we had a domestic to a domestic, we still applied a slightly varied version of the saw pipes test. We also allowed emergency awards to be recognized, emergency orders to be recognized as emergency awards. And so if you go back and look at that report, I think that if the government does allow most of the changes, at least we will have a good, not first step, but a first 4 steps in really allowing India to become a sensible destination of international arbitration. The next thing is, in a domestic arbitration, the arbitrators we tend to appoint, and this is perhaps where the university could give some ideas. The arbitrators that we tend to appoint are mainly retired judges. In other jurisdictions, you have a very thriving, what we call an arbitration bar, and an arbitration bench. And so people who work as lawyers on arbitrations, they really don't go to court. And the arbitrators are a much broader pool of people who, some of them have actually left when they were successful senior counsel, QCs, and decided we're not going to appear to court. We are actually going to do arbitration. And therefore there is a thriving bar and a bench, all devoted to arbitration. In our case, a lot of our good senior counsel and good junior counsel, they feel they're not going to make enough money and they're not going to be busy enough if only what keeps them busy is arbitration. So 10 to 5 court, 5 to 6 arbitration, 5 to 7 maybe, right? So the arbitrating litigant gets the short end of the stick. Now if you have a proper domestic set of arbitration law, you have a good thriving arbitration practice, then you will have a sensible arbitration bar and a sensible arbitration bench. What does that do? That just makes life go faster. And hopefully instead of the 3 to 4 years, our awards will be cut down to 2 years, 2.5 years. And that's a good start. If again, the courts start taking a Balco philosophical approach, even if it is pre-Balco matters, which they have started to do in various courts. They don't want to say that we like Balco because it is prospective. But they try and find every way to actually water down Bhatia and bring in the Balco perspective. So I think that we can do well. I have always complained whenever I have seen the relevant ministries or the bureaucrats that India is simply exporting its arbitration for no rhyme or reason. There's no reason you cannot get British arbitrators to come in here. They love the holiday. They love to see the Taj Mahal over the weekend when they're done. They drive the pace. They come well read. They know Indian law in that sense. It's Commonwealth. And they are very happy to sit here and run a quick arbitration. The litigant really has the question, am I going to be stuck because it is a domestic arbitration? And that's where the amendments to the Arbitration Act hopefully should make a difference. Now, have all of you, while I'm on this topic, do any of you have a sense of the problems that India is facing, again in arbitration, in relation to the bilateral investment treaties and the White case?
Yes, ma'am, we do. Most of us.
Yeah, you study the White case, right? So now look at that. What does the White case really tell you? Very interestingly, the White case, after the government lost in Singapore, government never appealed it. Government accepted White. And therefore, government just had to pay. But what does the White decision really tell us? That where there is a bilateral investment treaty, you are probably going to have a bit of a bad show, because the arbitrators in White held that if you allow a matter where the enforcement of an award goes ping-pong for 10 years in the Indian judicial system, then really the citizen of one of the contracting parties, in this case Australia, using the MFN Kuwait bit, I think, basically held that this was not fulfilling India's obligations under the treaty of allowing a citizen an effective means of enforcement. In short, without saying so, they read in that a poor judicial system without delay, although they went on to say the judicial system was fine, but they didn't mean that. They didn't mean that at all. What they meant is, it sucks. Now, the problem is, as I keep telling these, whenever I meet these people, that you're going to have 1,000 White cases. Because, and most of these delays, this ping pong, is by public sector corporations. And by an ONGC or a SAIL or a GAIL or just resisting the award because they know they have time on their side. White is going to come to haunt the government, and in fact after White, the government has really put the brake on signing any further BIT. The government has not signed the BIT with the US, which was almost ready to be signed, and the government is seriously considering how to withdraw from BITs. And if you tell the government that, this is not going to look good for India on an international platform, the response by and large is, it's just too expensive for us. Australia has decided to withdraw from all its BITs. Other countries have decided to withdraw from their BITs. But still, the sunset clause for each BIT is about 20 years. And so you are going to face this huge set of BIT litigation, which I think can be cured at least to the extent of 20 to 30% if you have good domestic arbitration clauses where the public policy exception is narrowed down to some extent. So that is on arbitration. Now, do you want me to take some questions while the topic is still hot and then move to FDI? Does that work?
I'm going to just take questions at the end.
At the end. Okay, fine. So now let's come to M&A activity in India. Now here we have Mr. Modi talking about Make in India. I am also deeply convinced that Make in India is going to give us our GDP. But we don't have a magic wand. And unfortunately, as of now, nor does Mr. Modi. So what do we have? We have a set of disparate statutes all going into what would make M&A activity good or bad. What do we have going for us? We have going for us the default setting. And the default setting is, unfortunately, because it shouldn't be, that's the reason. The default setting is that no multinational today can really afford to ignore India. So we are just an economy that cannot be wished away. We are a population that needs to be catered to. And therefore, if you look at the business plan of most global corporations, earlier it was India or China, now it is India and China, or China and India. And so you have this sense of companies who are our clients who want to come into India, but it's almost as if they have to double up their resources, double up their project management, and double up their energy to come to India, simply because they have to tick that box and then hope for the better. Now, actually, if you look at it, M&A activity domestically in India, first let's take the domestic piece, then we'll talk about the FDI piece. Domestic activity in India, in the M&A space, is not as active as it should be. Indian companies really don't buy out too many other Indian companies. And in India, you don't really see joint ventures between Indian promoters because they just can't work together. A lot of the larger companies are still promoter driven. And so you either see a JV with a foreign national or you see a buyout fully of one Indian company by the other. The latter is not as often as you would expect. I think a lot of it has to do with not really stepping on the toes of your competitor, some unwritten rule, or where the banks come to the protection of the promoter who is in distress, or the promoter who wants to buy out another promoter really can't get financing lined up for the acquisition. How many takeover hostile offers have we seen? I think AZB has probably done 90% of them, and the number may be 3 or 4, right? The system is not geared up for hostile takeovers. And again, if Why would you take over an asset in India as an M&A activity? One, you want to acquire something because it is better for you, there's more synergy for you. But why would one sell an asset? Either it's because you've lost interest in the business as a promoter. If you're a promoter-driven company, your family is not interested in the business. You've over-leveraged yourself and the banks are screaming DRT SARFACI at you. You can't find a foreign buyer who would give you a good price. So you are, again, as a domestic promoter, very often looking at another domestic M&A activity as a default situation. It's not your first choice, unless somebody is really offering you a sweet price. Also, for some reason, it is okay to sell to a foreigner. It is a little beneath your dignity to sell to an Indian. So the EQ is also quite evident when it comes to the trends that we see. Then let us see M&A activity from an FDI point of view. Now really as a practitioner, when we started as a small shop of 12 people called Chambers of Zia Mody 20 years ago, where India opened up for the first time, and India didn't allow foreign direct investment in almost any sector more than a certain amount. And suddenly now, if you fast forward to 2014, India allows foreign direct investment in almost every sector, except for a few. And so the game plan has changed, the rules of the game have changed, and it has become much simpler in that sense for foreigners to come into India. Of course, as you know, we have all those sectoral caps, which any country would have. We have obviously nuclear, defense, banking, finance, telecom, and all these are allowed but subject to certain conditions. But if you look at the new government, they've opened up real estate, they've opened up defense, they've opened up railways, and they're planning to open up a lot more. And so the landscape of M&A activity from foreigners coming in, I think, will increase, for sure. In fact, we have really anticipated that there will be a lot more work for us as a firm in classic M&A activity in the next 3 to 4 years. Also, private equity, which is another animal of M&A, has a huge amount of what they call dry powder. Dry powder is money where they have commitments at the back end from their investors, but which has not come into a country and not been invested. Why? Because the managers are not able to find a sufficient amount of good deals. And so it's not billions of dollars, it is trillions of dollars of dry powder. Again, where are private equity guys looking? Emerging markets. Can you ignore India as an emerging market? Answer is no. And so you see, we see at AZB, all the big guys, domestic private equity, all chasing the same deal, driving the values up, paying the promoter more than he dreamed of in his last 7 lifetimes. And this leads then again to a lot of interesting deal making. If there's a competitive process, you tend to be able to negotiate less as a buyer. The promoter is the king of the crop when he is in an auction process. Now you come to, so we've dealt with FDI, and of course you know things are under the automatic route, things are under the approval route, and that is really something that you get to know when you start practicing. Then you come to setting up a company. One would have thought you can set up a company in a week's time like you do around the world. Not so in India. You need everybody's driving license, his mother-in-law's name, his dog's name, his cat's name. It's painful. Yeah? So one of the things which goes into the ease of doing business is, do you really need the dog's name? Or what are you doing with it? Right? And so all these things are being relooked at, frankly, by the ministries to see how to do it. So you set up an Indian company and then you start doing the secretarial work, or you get someone to do the secretarial work, you issue the shares, and then you come across at what value do you issue the shares. Now, if it's a new company, the answer is simple, at face value. There's nothing there, it's a coca. But how many of you have studied the decision of the income tax in the Shell and the Sanofi case? Have you gone through that in terms of the transfer pricing on the share value?
No, ma'am.
Okay, I'll explain. So suddenly, as if Vodafone was not bad enough, what happens? The income tax department says to Shell, this is a 100% subsidiary, we accept that. But you put in shares at face value. Actually, the value of Shell India subsidiary is worth billions of dollars. And therefore, from a transfer pricing point of view, you should have actually put the shares not at 10 rupees, but at 1,000 rupees a share. And guess what? We're going to tax the differential. So, everyone went mad, and Shell thought India had gone mad. And finally, in a recent judgment, which you should Google, the High Court basically said, I think Mr. Salve argued the case. I think what the High Court said, the Bombay High Court, was that you just cannot apply the principles of transfer pricing in the case of a company wishing to subscribe to a primary issue. And so that got rolled back, and Mukul Rohatgi has made a public statement that it is unlikely that the government is going to appeal that Bombay High Court decision. So when you start your M&A activity, obviously you're looking to have a presence here, and then again, the tax laws. The tax laws have to be in sync with the advice that you're giving on the M&A piece. Now, as young practitioners, and even myself today at the tender young age of 58, I don't pretend to know tax. But I do know when my antenna is high for tax. I know when I have a tax issue. And I know when I have to refer it to a tax person. And that's because you have to develop an instinct for understanding when there could be a problem in a domain that you're not sure of. What else do you do when you are an M&A practitioner with foreign investment? You get to know your treaties. You get to know what Mauritius is saying, you get to know what Singapore is saying, you get to know what Netherlands is saying. You get to know the Hong Kong fact that we don't have a tax treaty. You understand why Vodafone was Vodafone. And that's another thing that you have to be very alive to in M&A activity in India. The next thing, of course, is the classic negotiations. Is it a 50-50? Is it a 49-51? Is it a 26-74? And as you know, under the Companies Act, all the different thresholds give you certain vetoes. And very often, youngsters put on the wrong hat. So if they have 51%, they want a veto over everything. And I keep telling them, oh, why don't you tell me what veto you don't have under the Companies Act? Because if you tell me that, then we can negotiate. But otherwise, the minute you are 51 are saying, I want a veto on dividend declaration, which you have anyway, by 51. The 49% guys say, oh yes, I agree. But it has to be mutual, huh? So in that, you actually lose your 51%. You understand? So the key is, when you start working and when you go into the big bad world, you have to put on what I always tell the youngsters here at AZB. You have to wear the right hat. You cannot just go in busy. Looking important, feeling important, and not have read your document. And put on the right hat. Actually, in some cases as a foreigner, you may want Indian domestic arbitration, but neither do. Okay. So really understanding where you want to go in a negotiation, where you want to be, and really focusing on the outcome. The next thing I'll give you before I start the questions. Don't negotiate for the sake of negotiating. It is the stupidest thing to do. When you have already got a point, quietly pocket it. Don't put it on the table to show off that you got the point. Because the other side is going to say, I gave you this, Zia. Now what are you giving me? But Zia doesn't even tell him that she's got something. She just puts it in her pocket. It's in the next draft. She's going to ask for the next point, right? Because you've not even let him think he's given you something. You just said, yeah, of course, that's natural, and you put it away, and next one. Negotiate smart. Don't try and impress the other side over something which he's going to feel he got shafted about. So very often youngsters come in and they negotiate and they get a good deal point, and then they go on and on and on about that till the other side gets so irritated that he either withdraws it or he starts trading for it. The art of good negotiation is to stealthily get what you have asked for without giving up too much in return. Now, that doesn't mean you have to do it sneakily, obviously not. But strategically, what I call purposive. Good M&A is done by strategic, purposeful lawyers. And that you develop that art as you grow older and as you get wiser. Again, in M&A, one of the last things that anybody looks at is the dispute resolution clause. All our M&A lawyers are busy negotiating tags, drags, ports, this, that, and then the last clause in the last 10 minutes is the dispute resolution clause. And I always say that, you should not be signing off on the final draft until a dispute resolution lawyer has actually been briefed, told of the situation, put on his hat, and decided what he wants to do with the arbitration clause. क्या चाहिए? नहीं चाहिए. पानी है इधर. लेके जाओ. कुछ नहीं चाहिए. So, what else? So I think that's pretty much it on M&A and on arbitration. Now we've got 10-15 minutes for questions. So, start.
Hello ma'am, I had a specific question regarding emergency arbitrators. You stated that the Law Commission said that has recommended emergency arbitrator orders to be converted into awards. However, there are international institutions, ICC, which has specifically said that they should be orders or in the form of interim measures given by an arbitral tribunal. So, why would the ICC recommend something like this if clearly an interim award would serve our purposes better?
Because the ICC is a global set of recommendations. I think what we have to do is Indianize it, right? So what is the point of having an emergency order if under the definition of award, so how is the Arbitration Act defined? Award includes a final award and an interim award. It doesn't include an order. So unless you say something about the emergency order being recognized as an interim award, there's really no point in having an emergency order. And the Singapore court has actually led the way and has basically taken the view, and I think amended the act as well, to the same thing. I think we lifted it from the Singapore Act. So check it out.
Good evening, ma'am. Much of the post and as well as during the election, there was a lot of talk about making investment much more attractive in India, and this is, I think, a reasonable time since 6 months have passed. So I'd like to ask you two questions related. Firstly, how sincere and how genuine do you think the government has been in its proclaimed commitment towards this particular aim? One. And two, how much of an impact do you think governmental interference in this regard can actually go to make the M&A and general FDI space in India much more lucrative?
So first of all, I think we're all a bit impatient as people. 6 months is not too long. you wait longer. I'm ready to. Second is, I think the government has done a fair bit of capturing of what I call low-hanging fruits. They've increased FDI in several sectors. They've made it easier in several sectors. Where are they still struggling? They're still struggling with the Land Acquisition Act, which was passed. It's very difficult to actually acquire land to build a factory or to build an industrial undertaking. And if you don't have land, who's going to come and invest in India? So that's one. The next thing is, of course, the whole dispute resolution issue, where the courts are a logjam. And therefore, although the theory is good, the practice is difficult. The third, of course, is corruption. The difficulty of coming into India and doing business because there is petty corruption at every level. Some of you must have studied, and I recommend that all of you study and get to know a bit about FCPA, Foreign Corrupt Practices Act in the US, which is something like our Prevention of Corruption Act, and how that impedes doing business in India, because US multinationals in particular are just not ready to pay any sort of petty facilitating payments, because the penalty for doing so is so severe back home that they would rather stall, get frustrated, not go ahead than suffer meeting the Department of Justice or the SEC back home. So I think that Mr. Modi is very fixed on the fact that he has to make the ease of doing business better in India. He gets to hear about that wherever he goes on his trips abroad. He has certainly given his bureaucrats the messaging of how to achieve that. But you know, unfortunately, it's going to take a bit longer. If you ask me how much time I give it in order for the effect to be seen, I would personally give it about 18 to 24 months.